Now starting. All attendees are in listen-only mode.
Good morning, everyone. This is Jo Donlin. I am Director of Outreach and Education at the Division of Professions and Occupations in DORA. Before I hand it off to the presenters, I just would ask if a few of you could raise your hand on the raise your hand and just let me know that you can hear me. Okay.
Okay, looks like we're good.
It looks like that is good. So I want to welcome everybody, and I think we are going to be able to access our Division Director, Ronnie Hines. Ronnie, can you hear me? She may be able to hear me, and I can't hear her. So, Nate, I'm going to turn it over to you. So please go ahead.
Okay. Well, good morning, everybody. Welcome to this town hall meeting. Like Joe said, my name is Nate Brown. I'm a policy advisor with the Division of Professions and Occupations. Thank you so much for taking the time out of your, I'm sure, busy days to come talk with us about these important issues. I also wanted to welcome you on behalf of Ronnie Hines, the Division Director. She was supposed to give some opening remarks, but you're having technical difficulties, as seems to be the case in COVID life these days. So we will just trudge on. Okay. So introductions. I'm going to go through. I have a fairly quick presentation for you all today. Hopefully no more than 10 or 15 minutes. So I want to give plenty of time for everybody to be able to make comments. But we do just want to kind of put everybody on the same page. So we have a few ground rules for you all, just to keep things moving smoothly. Go over sort of the background of the issues, the questions that this work group is looking at. An overview of the current laws, rules, and policies that are implicated by the work group's mission, and then just a little bit of data for you to consider as well before we open it up to public comments. So first off, we have a few basic ground rules that we hope will keep the conversation open, respectful, and moving along smoothly to give as many of you as possible a chance to speak this morning. Because our time is limited, we won't be able to discuss specifics of individual cases or complaints, and we ask that you keep any comments focused on the specific issues we are here to gather feedback on. With that in mind, just a few very basic ground rules. Be respectful of division staff and your other participants. We are here to try to come up with solutions to some pretty difficult, nuanced issues, and respect will go a long ways. Please also share your time. We do have quite a few people on the line today, and it's important not to monopolize the discussion. Please keep comments to 3 minutes, if at all possible. And like I said, try to keep your comments to the matters at hand. So the work group that this town hall sort of subject of was created by a recent piece of legislation, House Bill 2012-06, passed just this past legislative session by the Colorado legislature. It created this work group, Mental Health Disciplinary Records Work Group. Work group members were appointed by Ronnie Hines, the division director, include 3 licensed mental health professionals, 2 representatives of associations that represent mental health professionals in the state, a member of the General Assembly, and 3 public members as well. Specifically, this work group is required to address 2 main issues. The first one dealing with the timeline for which the division is able to make letters of admonition available to the public, and any exceptions for continued internal use of the public mental health boards. And then a similar question, but dealing with nonviolent felonies, nonviolent drug offenses that occurred before the date of application, essentially asking how far back in someone's criminal history a board is able to look when making that initial licensure determination. Similarly, in considering its recommendations on those two issues, the work group is required to solicit and accept public comment. The purpose of this town hall, public comment regarding the impacts of our current policies on consumer protection, the mental health workforce, social equity, and patient access to care. These are the issues that we are asking you to limit your comments to today. And we'll rehash these at the end of my presentation, just so you don't have to scramble to write them down. So as you could probably guess, there are a lot of bits of law and rule on the books already that sort of are implicated by these questions, by these issues, including restricting the kinds of criminal information that licensing agencies can consider, opportunities for record sealing and expungement, that sort of thing. We'll get into the details now. But just as sort of a baseline, the current law states that just because someone has, or let me put it this way, the mere fact that someone has a felony on their record cannot be used as grounds for denying someone a license. And I'm going to use the term license sort of generally to cover certifications, permits, registrations, different names, but I'm just going to use just for ease, license as a general term. So they have to look past that fact of conviction and to look at sort of the pertinent circumstances surrounding the conviction. The quote on the right of the screen is, and something just happened to my presentation. The quote on the right there is, that is actually from statute, right up, and it lays out that it is the policy, it is the intent of the legislature to give folks with criminal records a second chance, essentially. Like I said, current law restricts the kinds of criminal history information that's available to the boards, including arrests or charges not leading to conviction, convictions that have been pardoned, sealed, or expunged, convictions covered by an order of collateral relief. All of those cannot be considered when making licensing decisions. If the board finds that someone does have a conviction outside of those exemptions, they still have to take into account certain factors, statutory factors, including the nature of the conviction, the relationship between the conviction and the normal duties and responsibilities of the licensee, any evidence of rehabilitation and good conduct provided by the applicant, and the time that has elapsed since the conviction. It's a very important factor. Another important body of law implicated by this work group's mission is the Michael Skolnick Medical Transparency Act, which again is quote straight from statute there, but it's basically saying applicants for healthcare licenses, including mental health care professionals, are required to give the division quite a bit of information whenever they submit an application, either for initial licensure or renewal, including all public disciplinary action taken against them by any board in any jurisdiction, any agreements between themselves and a board to limit their practice. Those are often called stipulations. Any loss of employment for reasons that would also be grounds for professional discipline, and then any felony convictions entered after initial licensure. There's also a statutory opportunity for what's called conditional licensure. Under this scheme, a licensing board is able to, in a situation where they might normally have denied someone a license, they're now instead able to give that person a conditional license. The conditional designation, it does show up as conditional on their record, on their professional record, and it will state the reasons for that designation. However, that designation can be removed after a year or at the next license renewal, whichever is later, so long as the person remains free of any subsequent criminal conviction or licensing sanctions, and they're no longer serving any term of probation or parole. Importantly, there's a presumption in the law in favor of removing a conditional designation, and if the conditional designation is removed, that original conditional designation has to be made confidential, and then any reference to the crimes that form the basis for that conditional designation also have to be removed from the licensee's professional history. Like I said earlier, there are also numerous opportunities in state law for record sealing, record expunging, or otherwise making criminal records unavailable for public scrutiny, including opportunities to vacate certain drug felonies and replacing them with a drug misdemeanor. That's important. He's no longer considered a felon in that case. An order of collateral relief, that I mentioned earlier, which is a judge's way of saying, hey, mental health licensing board, you cannot take this person's criminal history into account for the purposes of this license that they're seeking. It's a fairly narrow form of relief there. And then much more broadly, orders to seal or expunge records would shield those from any other kind of scrutiny as well. Looking at the Mental Health Practice Act itself, the Mental Health Practice Act is the body of law that directly governs the mental health professions in the states. It sets the scope of practice, the education requirements, that sort of thing. It also dictates what the boards can and can't do. And in this case, it gives the boards broad discretion to issue various kinds of disciplinary actions against licensees, including denial of a license, refusing to renew, revoking, or suspending a license, issuing a letter of admission. Letters of admission are the center of one of the main questions being asked of this work group. Issue fines, place a licensee on probation, and then they can also issue what's called a confidential letter of concern. Just to clarify things a little bit more, letters of admonition are typically issued when a complaint or investigation discloses conduct that, while a violation of the Practice Act or some other statutory requirement, isn't necessarily something that would require maybe entering stipulations with that licensee or revoking their license or something that drastic, but it is something that the board feels should be made available to the public when searching for a healthcare practitioner, a mental health practitioner. Then one level below that, what's called a confidential letter of concern. This is for situations where maybe not necessarily a violation, or if it is a violation, it's not necessarily something that implicates public health or safety, but it could sort of indicate a pattern of conduct, and it's something that the board thinks that the licensee should be placed on notice about in order to not repeat that kind of conduct in the future. So it is the current policy of all the mental health boards that complaints that are dismissed with that confidential letter of concern are retained for 5 years and then disposed of in accordance with normal record management procedures, redacted, shredded, all of that. Importantly, letters of admonition are retained in a licensee's professional history indefinitely at this point. Okay, that was my very brief overview. I hope it wasn't too much information for you all, but just wanted to again get everybody on the same page as far as what the current regulatory environment looks like. Moving on, the division, as you can imagine, collects a lot of data on these issues, and I just wanted to present a little bit of it for you. Here are the lists. This is the past fiscal year, all of the top 10 most commonly violated statutory provisions in the mental health programs leading to discipline. As you can see, by far the biggest violation, or the most common violation, or failure to meet standard of practice. Unlicensed practice, fairly common, although again, compared to that first one, not nearly so common. And then all the way down at the bottom, tied for 10th, are felony convictions. Nine folks last year were disciplined for having felony convictions. Digging down just a little bit deeper, if we look at the last 4 fiscal years worth of disciplinary actions, complaints taken by the boards, excuse me, this is all of them combined, all of the mental health boards. As you can see, anywhere from 800 or so up to over 1,000 complaints are registered every year with the division, and upwards of 80% of them are dismissed, either outright or with a confidential letter of concern. By far the most common public form of discipline are those stipulations, right? Agreements between the licensee and the board to limit practice in some way. And you can see LOAs that are fairly far down on that list. Cease and desist orders, and then every year applications several of them tend to be denied, although any more applications that would have been denied in the past are typically given a confidential or a conditional license at this point. Okay, that's all I have for you. I know that was quite a bit, so I hope it didn't muddy the waters too much, but now we're gonna open it up for public comment. Again, this is your chance to help inform this work group as it makes recommendations on these issues. How it's gonna handle various kinds of information, letters of admonition and felony records. Please remember, be respectful. Try to limit your comments to 3 minutes, and keep your comments to the matters at hand, to those issues that the board is looking at, the work group is looking at. Just as a reminder, looking for comments on the impacts of current policies on consumer protection, the mental health workforce, social equity, and patient access to care. And with that, I will turn it back over to Joe to see if there are anybody. It looks like there are plenty of people who have their hand raised. So,
okay.
Let's open it up.
Okay, great. And the only other thing I would want to ask, you can ask your questions in 2 ways. You can either raise your hand again, and we will try to unmute you and you can speak live, or you can put your comment or question in the question box, in the chat box, and I will look at those and I will read them out loud. We do have about 100 people online today, so we are going to try to get as many people as we can, but please know that if for some reason you are not able to ask your question or input your comment or provide a question that you want the work group to look at, please be sure to write it in so that it is on record. Or you can also obviously send anything written to us as well. The other thing I wanted to emphasize that Ronnie was going to speak to is that there have been no decisions or any recommendations drafted or made at this point, and your input is really important to inform the discussion so that the work group can really work to address the problem and learn what the problem is so that their recommendations can directly address that problem in a reasonable way. So again, just please stick to the topics at hand, and I am going to, let's see, start at the top. I'm going to start with Carla Cruz. Carla, can you hear me? Can you?
Yes, I can.
Please go ahead and state your name and who you represent. And just so everyone knows, this is being recorded so that we can post it on the website once the event is completed. So go ahead, Carla.
Yes, so my name is Carla Cruz and I represent myself. I'm a licensed marriage and family therapist. I also once was a certified addiction counselor, which I voluntarily surrendered because of a situation that was requiring me to do a monitored practice for a period of time to get that back. So I decided to voluntarily surrender it because I disagreed with the board's outcome of the complaint. And then I also was a registered psychotherapist before I was a licensed marriage and family therapist to earn my way to get my LMFT. So my LMFT is in good standing, but I do have a letter of admonition on my registered psychotherapist, which I no longer have active, but it's still open to be seen by the public. So I think my main concern with that all three of, or I guess there's 4 boards, but they all have different levels, and it's really unclear, I think, to the public as to sort of how the different boards have different criteria for what is, I think you put on there, failure to meet standards of practice. The thing that I was, I guess found guilty of in the board's eyes, I wasn't even aware of would be, a violation of the standards of practice. And so I think one of the biggest things that I would suggest is more education to the licensees from the boards of what is considered a standard of practice. I do feel like it disproportionately affects low to middle income practitioners because to understand it, you pretty much need to hire a lawyer and also have a lawyer be able to explain to you all of the changes that take place, especially with the act that you referred to in the 2010 Act. So I feel like the biggest, if you want to call it a failure, is just in general being able to educate practitioners what is considered the standard of practice. I mean, you showed that that was the highest level that practitioners get are seen to violate. And so to me, that's a reflection of the poor education that the boards they don't educate the licensees as to what that actually is, and it often changes. And so again, you would have to have enough income to have a lawyer represent to stay on top of those things. And I think that shouldn't be standard that you have a lawyer to be able to inform you of those things. That should be the responsibility of the state. And the other comment I would like to make is that because the letters of concern, I didn't get to it in time to see how many numbers that reflects, like how many people get letters of concern when a complaint is issued. I think you put it in there, but I wasn't able to see if that was how high that was, but some way that practitioners can earn their way to be removed, to have that removed from their record. I unfortunately, it was my very first job in the industry, and this had happened to me a year after I became a licensed practitioner. And so I was very uneducated, and I didn't understand a lot of the things. And so for me, that's going to be on my record for, the rest of my career, and having some way to earn my way, off of that, I think would be a fair thing that practitioners would be able to engage in. And that's the extent of my comments. So that's all I have.
Thank you so much for those comments and how they were direct on the topics today. Nate, do you have anything follow up on that?
I don't, but I appreciate your comments. Thank you very much.
Okay.
Thank you.
The next person I will unmute is, and I'm sorry if I butcher these names, Chris Pharrell. Chris, you are actually self-muted. So if you can unmute yourself, there you go.
Yes. Yes. Good morning. Thanks for the opportunity. I was invited as a stakeholder, as an individual on behalf of my minor children, reporting concerns and what I felt was some questionable ethical practices of mental health care providers. I chose to do so after seeing on the news the chance of school kids requesting mental health. And I chose to do so after I felt that my children's mental health was actually further impacted, where we actually went to gain help with mental health. I also decided to launch my grievances with Dora on these mental health service providers, two to be specific, in finding a letter of condemnation on one, in which seemed to very much reflect my concerns of the mental health care of my children. And in that case, it happened to be what appeared to be a failure to report mandatory information. And to me, having that letter of condemnation sitting out there was the decision factor that this person is already being policed. If we as citizens don't speak up, there could be some serious mental health damage to children here. The same provider collected money from my elderly parents for the services without my knowledge, and that to me was direct to the most vulnerable, the minors, the young, and the elderly. And to me, that is not a good situation. So I appreciated the opportunity to report my concerns to Dora, and I appreciated the opportunity for the information to be released. The other factor was we have a high rate of suicide here in Colorado on our national statistics. And the concern here is mental health and how we're best helping children and mental health, specifically teen suicide and those types of things. And as I witnessed my children's behavior while seeing these providers that I had concerns with ethically, I became very concerned of the potential of suicide. As a matter of fact, one of my children was professionally diagnosed as SI post this professional's care of my child. So I appreciate what Dora does. I appreciate the opportunity to review records, to make a cognate decision as to whether to report or not. I'm a very easygoing person. I don't like conflict, but I feel that Dora is the peacemakers and the policers where citizen protection is required. And that's basically all I wanted to state. I appreciate the opportunity for you to allow me to put my input in. And I appreciate everything that Dora has done in the protection of my children's mental health. Thank you very much.
Thank you very much, Chris, for coming today and for your comments.
Yeah, much appreciated. Thank you so much.
Let's see. The next one is Diane Hayer's Behill. You are self-muted, Diane, so let me see if I can get you. You're self-muted, so if you can get yourself unmuted on your end. So, okay, Diane, I still see that you're self-muted. So Diane, if we're not able to hear, please be sure to write in your comment if you want to down below, but I'll come back to you and try in a little while. Next, I will go to Donna Harrington. Donna, it looks like you are self-muted, so if you want to unmute yourself. There you go.
Thank you. Thank you for the moment to ask a couple of questions. I apologize if I'm not better spoken.
You're doing fine, Donna, so don't worry about that. Thank you for being here.
Thank you. I have been a licensed practical nurse since 1978. And during that time, I've spent probably collectively 15 years working as a nurse without ever having received any admonition letters from employers. During the last year and a half, I have gotten, as well as in the past, many letters of recommendation and accommodation. Having said that, in 2011 or 12, I'm not sure which, several years ago, I received a letter of admonition from the Colorado Board, DORA, and it was in direct reference to a situation in my personal life where I defended myself against being physically attacked brutally over several times. I finally defended myself. During the time that situation happened, I was incredibly cooperative and did everything I was told to do through mental health and through the legal system. And ultimately that was dismissed, as well as sealed. The attorney that I hired about 2 years ago, I requested an attorney, very gentle attorney, not a shark, to help me request from DORA to please change a wording of the letter of admonition, which was hurting me in employment because I had not worked for a few years after taking care of a mom who had Alzheimer's for 5 years. I worked, but not as a professional. Having stated this in a little bit of a picture of the history, DORA did respond to changing the letter of admonition, but did not respond to removing wording or putting the letter in a closed state which was not open to the public. The letter still remains. And as I try to move to a different state where I have a compact license, that letter's hurting me in employment. In my life, I have never had any other thing in my private world or my professional world smudge my good name. In fact, the director of nursing of 2 school of nursings has given me incredible recommendations. My question, as you go forward looking at how long do you let these letters of admonition stay on, I can totally see where it needs to be individually evaluated. But my question is, what is the ultimate purpose? I do understand protecting the public completely. I now work with the aging population and have never called in sick, never done anything except get accommodation for what I do, especially during COVID. I feel, now this part is a statement, I feel strongly that people do need to be policed. As the gentleman just mentioned how appreciative he is, I do feel like there needs to be someone to look over a shoulder of all mental and medical health professionals. But at what point, and I think that's what you're trying to decide, do you say, this person really does no longer deserves to have a public letter? They have been slapped on the hand, and I was slapped on the hand very mildly at the lowest, what I thought was the lowest level. But it's difficult to explain that to prospective employers, even when you present them with glowing letters of recommendation from many crossfires of professionals, including legal, ministerial, medical, physicians, nurses, and directors of nursing, as well as I have people who have written me letters of commendation who work for outside companies internationally. And I also worked for an airline for 20 years during the time. So I'm personally hurt professionally by this letter of admonition being public. I would like to see a time limit that's very reasonable. Once a person does everything you ask, even the law allows for people to go on with their lives as long as they don't continue to do something wrong. And I feel strongly that in my case, and I'm sure there are many others, judging on the numbers you put forward, that some of those cases deserve relooking and removing those letters, or at least putting them closed to where you don't get yourself put in a position of, oh, let me explain to you, this had nothing to do with me professionally. For some reason, it falls under the Nurse Practice Act. We're supposed to be really perfect in all areas, and we're not. We're just humans that make mistakes. And I feel like in my particular case, it's understandable whether it's acceptable or not. And yet, I could not get the board, once I did hire a lawyer to help me, to even consider it. And that was an enormous disappointment and an unfairness, because I want you to be fair. I want you to be reasonable, and I don't want people out there working with the public, the children, the elderly, the sick, who in any way will harm them, ever. I have been harmed. I don't want anybody harmed. I don't even like sticking a needle in a patient, because I tend to say every time, oh, I'm sorry, I don't want to hurt you. If this does, please let me know.
Right.
And we all know we have to hurt sometimes just to do the procedure. So please let me know soon when you make your, and the second question, how long before you will make a decision on these types of cases? And thank you.
Thank you, Donna.
Just really quick to that point, to your last point, the work group is required to put forth its recommendations by January 1st, 2021. So they'll meet a few more times here, well, as often as needed, but a couple of more times probably over the next few months, and then they'll have that report will be issued to the governor, to the division, and it will be made public as well. So January 1st, you should have that available to you.
Nate, we have a request by writing that asked if you could repeat the first consideration for the work group. Maybe you can pull that slide up that talked about the first.
Oh.
There are two main questions that the work group is charged to address. So
yes.
One is very specific to letters of admonition, if I'm correct, right?
Yeah, it should be up on your screen now. You said the first one is the timeline for which the division shall make letters of admonition available to the public, and any exceptions for continued internal use by the mental health boards.
And maybe show the second question as well.
Yeah.
The next
second
slide.
question. There we go. So this one is the timelines, parameters, and conditions for which the division is authorized to disclose to the public records for certain felonies, deferred sentences, or felony charges that are nonviolent, including nonviolent drug offenses that occurred prior to application for initial licensure.
Okay. So again, those are the two things actually in the bill. So I'm going to read some of these questions that we can forward. Some I think pertain to this, but I want everyone to be able to voice. So one was, I recently filed a complaint against a former mental health therapist of mine. I requested to read her response, but was denied. So the question is, should one be able to read the complaint but the other not being able to see the response. So that's a little bit different from what we're talking about today, but I appreciate that, and we will certainly keep it in the queue as something that was offered today. This question was, if we have a complaint filed against us, will we be given the name of the person who has filed the complaint? Again, that is a little bit different from where we are today, but we will forward that as well. This comment is there movement toward a sealing or dismissal of letters of admonition? I have worked for years in the very high conflict field of criminal justice and divorce. I have spoken to many mental health professionals who will not accept cases based on fear of retaliation by an unsatisfied client. This leaves a gap in highly qualified services providers. But I think your main question is there a movement toward a sealing or dismissal of letters of admonition? And what we just reviewed, that's part of the question that the work group will be answering. Correct, Nate?
That's correct. That's the issue that is at the center of that first question. Yeah, is how we deal with those letters of admonition.
Okay. Another person asked, as far as, are there any similarities in regards to developing countries in what they might be doing and how they may be handling? So that is another. Okay, I'm going to go back to live questions. Okay, I'm down to Kimberly Hartman. Kimberly Shirtliff Hartman. Let me
Oh,
There you
okay.
go, Kimberly.
Hello, I'm not used to talking like this, so please let me know if my voice is too loud or soft.
Oh, it sounds good. So I think you're doing
That's fine.
Thank you very much. And I appreciate the opportunity to speak briefly. I had a complaint against my license in 1999, and for which I received a letter of admonition. In brief, I was performing an emergency psychiatric mental health eval in an emergency room in a hospital here in Colorado Springs. A patient appeared that was not psychotic, but was threatening to murder another individual. I was asked to do a quick evaluation and report to the psychiatrist on call. I did. I would have liked to have admitted the man because it was after midnight. It was like 1 or 2 in the morning. It was really late. And the psychiatrist talked to me about the clinical presentation. The gentleman had done violence in the past. He'd beaten an infant that was later removed from him. And he'd also beaten a man who was harvesting his illegal pot grow and said he beat him nearly to death. So the guy had a history of violence. He was threatening violence. He had access to means and a plan. The psychiatrist did not want to admit him because the murder threats were not related to clinical issues. They were related. There was no voices telling him to kill. He was coherent and not psychotic. And so at any rate, the psychiatrist elected not to admit. The emergency room doctor spoke to the psychiatrist too. They both concurred that we would not admit, and I was directed to do my duty to warn, which I did, but that was before the law that protected providers when they're doing their duty to warn. So I did my duty to warn, and then the doctors and I our licenses were complained against because the person lost his job for threatening to kill his boss. And so what ended up happening to me is I told the complete truth to everybody, the doctors and the psychiatrists, that I'd handled it properly. My boss did, the hospital did, but the investigator had never ever talked to anybody that did this kind of work in a hospital setting. And I tried to explain that I licensed, but I couldn't overrule a doctor. I'm not qualified to overrule a psychiatrist. And so at any rate, I got that letter of admonition because a psychologist who is not on our staff, did not have privileges, but who was seeing that couple for marital counseling, wrote a letter saying if I had just called and awakened him at 2 a.m. and talked to him, he would have talked me out of the duty to warn, which isn't true because it was based on the clinical presentation in the emergency room. And I got that letter of admonition, and I have to tell you, it just is like it was like a gut punch. I didn't know. I was shocked. And so I didn't hire an attorney to fight it because I had told the truth and the doctors told the truth. And I thought, well, then I'll just take my punishment. I had no idea that that would mean I've lost so many jobs, so many opportunities. I've been denied access to panels I used to be on before this happened. And so it's been more than 20 years and it's permanently on my record. And when the law changed to protect people who are exercising their duty to warn, I contacted the National Clearinghouse as well as the state to ask if I could please have this revisited. And they both refused. The National Clearinghouse would not release it unless the state did. The state wouldn't even consider it. I called an attorney and he said if I talked to him 20 years ago, he could have helped me, but he couldn't help me now. And so I would desperately like people to consider at least giving us an opportunity to appeal after a while. I did not claim this at the time because I kept it private and I've never asked for accommodation, but I'm also a consumer. And I think I might have fought it if it hadn't been such a gut punch to me. And if the doctors hadn't all backed me and the board didn't. And so I guess I'm thinking we should have an opportunity, especially since the law has changed and people aren't allowed to file grievances when people exercise their duty to warn anymore. I don't think. I think it at least should be ended now. It's already been 21 years.
All right.
And that's all. Very much for the chance to speak.
Thank you, Kimberly. Really appreciate you being here today to share your story.
Thank you, ma'am.
Thank you.
I'm going to go to one of the written comments from Kristen Mason. And again, these will all be forwarded as well as the recording, all of your comments and issues to the work group. So she says, I practiced with a stipulated license supervised through peer assistance services for 3 years. My license has been active without conditions for 3 years now. When will this no longer be on my record? Also, will this haunt me for the rest of my life whenever I apply for a job? A very common application question is, have you ever been reported to a licensing board? So thank you for that, Kristen. It really helps to have these examples to inform their discussions. Do you have any thoughts on that, Nate?
No, I just appreciate your comments. Question. Thank you.
Another one from Sherry Johansson. Is there a measure on the table to require this? I doubt that I have course records from 20 or more years ago. So again, looking at all the options to address this problem. Let's see. This person has written that I would promote the position of I'm so sorry about that siren that just went by. I would promote the position of allowing a mental health professional to be present at deliberations over a complaint. I was recently grieved by a client who was in the intake phase of working. It was ultimately dismissed, but really took a lot of time to recover records, etc. So just more about consider taking a more inclusive approach at reviewing complaints and justifying any actions taken. Okay, I'm going to go back to, we have about 10 minutes left. I'm going to pick on Leanna Hale. Let me unmute you, Leanna. You are there you go.
Thank you.
There you go.
Okay, so I have a couple comments to share. I do agree with time limits regarding letters of admonition and instituting a process to have those removed from a licensee's record or sealed at the least. As well as I think there was a comment in regard to the opportunity to appeal them after a certain period of time. My question here is, do you keep records of people who file complaints against licensees? I work in a very high conflict field of divorce and parenting, as well as I've had history working in criminal justice. And I know there are folks out there who just love to complain. Early in my career, I had a situation where I was working with a family with a juvenile sex offender, intrafamilial abuse, and we were looking at reunification issues. And the mother had grieved, I believe, 4 of the therapists who were involved in the working team simultaneously. So I just wonder if DORA does any tracking of the type of folks who are making complaints, the frequency of those complaints, and as well as just getting a response from DORA when you have had a complaint filed against you, regardless of the outcome, would be very beneficial, I think, to the professionals who work and are governed by DORA. I was the one who actually was recently dismissed from a complaint that was filed regarding a supervised parenting time case. However, I didn't know why it was dismissed. I didn't know if it was an issue of jurisdiction or if it was an issue related to the quality of my response and the work that I had put into it. So that would be very helpful for us as professionals moving forward in the field as well. Thank you.
Thank you so much for those comments. Next, I'm going to unmute Patricia LaPlante. Patricia, you're self-muted, so be sure to hit your mute.
I did not indicate that I had a question. I was just listening.
Oh, okay.
Sorry.
That's all right. That's fine. Thank you. Sorry, don't mean to put you in the hot seat unnecessarily. And below Patricia, I have a Peter Barber. So Peter, I'm going to unmute you. You are, there you go, Peter. Go ahead.
Yes,
Peter.
Thank you. So I work for a law firm, Robert A. Lees and Associates, where we are, our clients are mental health professionals, and we are constantly involved in their grievance defense. And so I would just like the work group to take into consideration what has already been mentioned several times, that the letters of admonition, that it be introduced into law, that those be on some sort of a time limit. We have seen client after client after client receive an LOA for violations that we felt didn't warrant an LOA, probably warranted an LOC instead. But because they did receive the LOA, and because that is indefinite, we have seen countless stories of our clients encountering many of the same scenarios which have already been mentioned on this call. It prohibits their ability to continue to work, limits their professional capacity to continue to provide good therapy. And so that is something that we are very interested in and want to see the work group take a look at, especially in cases where the LOA was issued for deficient disclosure paperwork.
Case is dismissed.
So the case is dismissed, whatever triggered the original complaint, that is dismissed, and yet our clients still receive an LOA for a deficient disclosure statement. And as has been stated repeatedly on this call already, that LOA is a significant impediment to future professional growth and development. And so if this work group could really take a look at addressing time limits on LOAs, I think that would be not only very helpful to our clients, but I think it's helpful for the professional development of therapists in this state.
Thank you very much for your comments and for being here today. I'm going to go down to the end of the alphabet since we only have 5 minutes left. With Medford, do you want to go ahead?
Yeah, thank you for taking them. The quick question about for people that apply for a license or people that have the letters of admonition, you know, making sure that the appeal process is a fair process and that there's options for people to have that appeal heard. In my much younger days, I was in another state, and I was, in the criminal justice system. And in the particular case, it was a license to be a licensed marriage and family therapist. And what ended up happening was the case was kicked to an administrative law judge. It was able to balance the needs of the state licensing board and also the rights of myself as appealing the original denial. So ultimately, it was approved. But I just want to make sure that there's an appeal process for people that are applying that have lived experience. And my concern is that that when someone has a criminal record or someone has a particular issue that comes up, that there's a fair and balanced way to look at those charges, look at the time spent, and then fairly evaluate the stuff that people have done to turn their lives around. And it's really based around the fact that we're losing a bunch of people in the licensed addiction counselor field or the certified addiction counselor field because they're retiring. And I think if we tighten the screws too much, then I think that we lose the option of great people doing the work. On the other hand, we got to make sure that we're diligent and making sure that we're not turning people loose that are not really prepared to take on the awesome responsibility of sitting with a client in an individual office and working toward getting them back to the place and get their lives back. So I think some consideration around how that process works and who the people are that sit on those panels that can review those applications from people that may have complicated records.
Okay. Thank you very much, Wade. Okay, we've only got a couple of minutes left, and Nate, I want to throw it back to you just so that you can talk a little bit about next steps and future meetings and all of that so that people can be informed about when those are happening.
Sure. Yeah, first I just want to thank you all so much for taking the time to come here today. I hope I already mentioned that public comment, civic engagement is paramount in work. I mean, we wouldn't be able to really do this without you all being engaged. So I appreciate you taking the time today. As far as next steps, I think we've mentioned this is being recorded. All of your comments, written comments and spoken comments will be compiled and given to the work group members as they start formulating those recommendations. Like Joe mentioned, they've only met once at this point and are still very early in that process. So you all are sort of in on the ground floor, as it were, to help really shape this conversation moving forward. Like I said, the work group will meet a couple of more times throughout the fall and winter here. Actually, on the 19th, which I think is Monday, the work group will meet at 2 p.m. Virtually, of course. If you go on DOOR's website, on DPO's website, there should be a link there that you can register for that. Although, because it's the setting, it's a work group meeting, members of the public will be free to attend, but there won't be any sort of real opportunity for interaction during that work group meeting, but you will at least have the opportunity to listen in as they discuss these issues. There will also be, like I said, there will be a couple more meetings throughout the fall, and those will be posted on our website as well once that information becomes available. Looking forward, the work group will, by January 1st, draft and present their recommendations to the governor and to the mental health boards for possible regulatory and or statutory changes. So I want to assure you all that what you've said here today could very well impact policy moving forward. And it's, again, very important that you all are here, and I really appreciate you taking the time.
And with that, it is 12 noon,
yeah.
and I also want to thank everybody for hanging in there. I'm sorry our director wasn't able to give her direct comments, but I think if she were here, she would certainly thank you all for the work you're doing to all the professionals on this call that took an hour to come and give your input when we know that the mental health needs during this COVID epidemic are extreme, and you are all working very hard on those issues. So with that, I thank you again. This recording will be posted on the Mental Health Board website, so keep an eye out for that. And with that, I will say good afternoon and thank you very much for participating.
Thank you, everybody.